company is generally made up of tangible and intangible assets, of which not all intangible assets can be made in IPs. And in the context of startups, there are times when filing for an IP may not be recommended, especially if there are confidential information that should be kept trade secret. But however, at the same time, IP can help companies in many areas, including maintaining a lead in their respective fields. And so before I hand over the time to Rizvi, can I get the audience to type in the chat box which industry you are in, just for us to get a better sense of who we have today. I'll give about 15 seconds more for the rest to type in. So far, I have seen people from ICT, FinTech, digital health, cybersecurity, retail, a wide range of industries we have today. Okay, so thanks everyone for their participation. And so with that, Rizvi, over to you.
Good afternoon, everyone. Okay, my name is Rizvi. I'm a lawyer specializing in IP and technology. I'm practicing in RHT Law Asia LLP. I'm very delighted to be here this afternoon to share my views on IP mapping and what it entails and what are the possible benefits and value you can get from such an exercise. Now, before I begin, I thought it might be useful to actually mention a little bit about the basics of IP, just in case. Okay, so I like nothing better than to illustrate with an example. Huh? Okay, the simple iPhone that I have here. Now, if you look here, you can see there is an Apple logo. Now, that's a trademark, okay, that actually essentially covers brands. Now, the shape of the phone itself, that's protected by registered design. Okay, the inner workings of the phone, right, could be protected by a patent. And you see all of these icons and some of the creative works in the apps and all that. These could be protected by copyright. Okay, again, this is just a brief example. It's not meant to, give you a crash course on IP, just to give an illustration. So, okay, so what you may ask is IP mapping. Okay, now, in essence, it's the exercise of recognizing all IP rights that you have in your material, your assets, or your works, especially the non-obvious ones, with a view to identify, recognize, protect, and even commercialize those hidden IP rights. Okay, so essentially, IP mapping gives you options. It enables you to say, hey, I didn't know that I had so many other rights to consider from a simple invention, a simple product. Okay. Now, before I go on to the stages, I want to illustrate by a simple example of what I mean could be an exercise in IP mapping. Take, for example, wine. Simple wine, red wine, okay? Now, wine itself, right, you can actually consider 3 or 4 different types of IP rights, depending on which part of the process and which aspect of the whole winemaking process and commercialization. So if you, for example, have a new grape variety, crossbred, okay, plant variety protection, that could cover the new breed of the grape. If you have a new bottle designed to house your wine, that could be a registered design. If you devise a new method of bottling the wine, that could be the subject of a patent. And finally, if you devise a brand name for your new wine, now, depending on whether or not there is a artistic work or a logo involved, it could be both a trademark and protected by copyright. So a simple example of wine, you can have so many different types of IP, depending on which part you look at, how you want to protect it, and which part is most important for you. Okay, so now we're going to look at managing the stages. Now, the identifying part is fairly straightforward. You just need to have an eye for it. Commercialization is also fairly straightforward. You just need to know how you want to make money. The only point I want to emphasize is this: managing. Now, the managing part, managing the IP, the most important aspect is deciding and resolving issues of co-creatorship. In other words, if more than one party contributes towards the creation of the IP, it would be very prudent and it would be very prudent to resolve issues of co-ownership and or allocation of any benefits, whether it's from rewards, royalties, or you're paying off someone just to acknowledge their contribution to the creation of such assets and such IP. Okay, so if we move on to the next slide. Carmen, if we move on to the next slide. Yes, okay. So the value of IP mapping. Now, the most obvious one is, of course, you have additional IPR. And of course, the value of your company. Because the more value you unearth, the more value you discover, the more valuable you could conceivably create for your company. So it's like unearthing hidden treasures. Okay, and whether you're a startup or whether you're a long-established company, right? I'm sure if you look hard enough, if you look close enough, you will find additional IP rights. And of course, during IP audits and due diligence, right? Somebody sharp enough will be able to identify all these additional IPR. Now, because it's valuable, right? When you flip over to the next slide. Okay, when you flip over to the next slide, you will see that it becomes most useful, especially when you are talking about M&A, insolvency or commercialization plans. Now, the M&A part is obvious, right? When you are thinking about, shall we say, valuing your company, right? How, or rather, you will want to boost the value of your company as much as possible. And unearthing hidden treasures, hidden assets, hidden valuable IP will definitely contribute to the value. Now, insolvency and restructuring is a variation of the same theme, right? Unfortunately, nowadays, especially during the pandemic, there are several types of businesses which fall victim to such a situation. And the idea is, if you are forced to go into insolvency and restructuring, will you be able to maximize the value of the your assets. And IP mapping can play a part here in helping to, again, boost the value of your company when you're considering, say, a fire sale. Okay? And of course, when you're embarking on a new commercial plan, right, that's quite important, right? I talked about giving you options, okay? So if you can imagine, you have a certain asset, you want to know whether you can do a patent or registered design or copyright or trademark. Okay, it's not all alternative, but it's either or, one or the other. Then you ask yourself, which best suits your commercial plans? Okay, you must also remember when you are trying to obtain patent protection, the trade-off is that you will have to reveal your trade secrets. It will be published in the public domain. Now, is that something that is worth the monopoly that you obtain for a limited period of time? Or is it something that you wish to keep a trade secret? I mean, I can only cite the example of Coca-Cola and maybe even KFC as examples of recipes which have never been in the public domain, which are not part of any patent, and have been kept secret as trade secrets all of this time. Okay, now.
Thanks, Rizvi. I think at this point, maybe we will just pause here. Could you elaborate? So you shared a lot on, I guess, when instances where IP mapping might be valuable. And also, I guess, when it is useful, specific to startups. Do you have specific examples to elaborate on, say, in the case of M&As? Because at this point in time, there might be, because of the difficult situation, we might also see companies, more M&As happening in general, where portfolio startups may potentially be consolidated. Yep. So if you have any practical advice to share on that.
Well, I can think of one example which I came across many years ago. We were actually helping someone acquire a source. Okay, we were actually helping someone acquire a source. Okay, now that source actually was quite well known. Okay, so traditionally you will only look at the brands, the trademark, the what do you call it? All the registered trademarks throughout the world. What is how do you measure the goodwill in that brand? And then you only look at the trademarks. See, but while we were doing our due diligence, we discovered actually that the company had made over the years, they had made advertisements, TV commercials, print advertisements, and both locally and in the region. There were some foreign language advertisements as well. So we said, okay, look, the value of this brand is not limited to the registered trademarks. It also encapsulates what was, what do you call it? It also encapsulates what has been put in the public domain as part of generating goodwill, awareness, brand awareness, and goodwill and brand awareness through the medium of advertising. You see, so we said, okay, all of these things have to be included into the IP that is to be transferred. In other words, all the copyright ownership in all the advertisements, whether it's TV commercials, print adverts, all of these things have to be included. And so there was an investigation who actually held the ownership, the copyright ownership of all of these other materials. Now, so all of this contributes to the value of the brand. You see, so in addition to the trademarks, there's also the copyrighted material. I mean, if you want an example, that's one thing. And then so when you acquire the brand, you need to make sure that all of these things come along together with the trademarks.
Yeah. So
Okay.
on that note, is it possible to evaluate how much an IP is worth?
Well, I'm told that it is actually an exact science, but it presupposes um, some kind of existing revenue already generated over a certain period of time, and then you just multiply that according to the shelf life of the IP. So, as a very simple example, say you have a patent and you are generating, I don't know, $10,000 a year. This is just a hypothetical. And you have like 5 years left on the patent. Now, logically, the maximum value of this patent is 50K. Logically, okay? Because that's maximum 5 years left and it's 10K a year. So all things being equal, the valuation could be 50K. Of course, I'm using a very simple example. Okay, there could be other factors involved. Things like advertising costs, things like manufacturing costs and all that. Okay, but this is just one example. Now, you put it into the context of a IP mapping. Okay, it's not just simply like, say, the pattern itself. Okay, if you're looking at the whole system, the whole product, right? Say maybe there's a product involved, of which the pattern will cover maybe the bulk of the revenue. Okay. Now, if there's other things that are required in order to assess the revenue, then you need to look at other things as well. You see, for example, it might be the case that you need to have some kind of you're dependent upon other systems. Okay. Now, the value of those other systems has to be included in the valuation as well, right? So, in terms of the mapping issue, number one, you need to have a full intelligence, full information on the whole system. You need to understand where everything is. You need to understand how long more you have, right? And then you need to understand, okay, can I make improvements? Or are there improvements available? Okay, so information, the full overview, the full landscape is very important when you're doing this.
So on that note, you also mentioned product as well. Then in the case of AI startups, which I believe there are some AI startups here, would you consider proprietary AI algorithm as an IP asset?
You see, here I am caught in the dilemma, you see, because you see, even if an algorithm is patentable, now as long as you satisfy the requirements of a patent, it is patentable. Now, so what I'm saying is that even if it is patentable, should you be obtaining a patent over your algorithm? You see, because there is a trade-off, as I said. You are going to be revealing a lot of your trade secrets when the patent is published in the public domain. Okay, and there are enough intelligent people out there who will know how to circumvent the patent without infringing it. Working the invention, circumventing the patent claims, right? Avoiding patent infringement, but at the same time, taking your, the know-how within your invention. Okay. Now, so firstly is, if you ask me whether it is patentable, I will say probably. right? I believe there are people who've already obtained patents for algorithms, and it is, if it is their commercial decision to say, okay, we want to commercialize because we want to get protection. We want to make sure that no one else copies our algorithm. That's fine, okay? But the trade-off and the risk that you take is that people who are clever enough, they can decipher, they can decode what you're doing. They say, okay, look, maybe we can replicate something similar, but outside the boundaries and the confines of the patent, so as to avoid any risk of patent infringement. But we have already extracted some value from the trade secrets which have been publicized in the or published in the patent itself.
And so I guess this also provides a very nice segue into our next section. So when we're talking about relevance of IP, right, in the various industries, we have a number of industries that are with us today. I think in particular, could you give some example of case studies, or that you are aware of in the industries such as aquaculture?
Case studies. Okay.
Or any of the industries that are listed here, or may have information that can be useful, that can be applied across industries as well.
Well, the first thing I will say is that if I use general principles, number one, keep an open mind. Keep an open mind on anything that you have created. Because once you have an original creation, whether it's a product or a artistic work or a new breed of a flower or a plant, right? Keep an open mind. What IP rights you can obtain, okay? Now, there is these obvious rights. There's also the ancillary rights, the related rights. So the related rights are the ones where if you like, the magic of the IP mapping exercise will actually enable you to maximize the value of that asset or that product. Okay, so having an open mind is one thing. Then after that, you need full information, right? You need to ask yourself, okay, look, number one, should I patent my invention? What are the pros and cons? Okay, has anyone else patented something similar, right? Does it make sense for me to actually risk publishing my trade secrets, my innovation in the public domain through the patent system, right? Knowing that anyone with the requisite knowledge and intelligence can actually, shall we say, work around the patent system, but extract the value from my innovation and technology and know-how. Okay, then you make a decision. Okay, if the commercial position is that it is better for you to get a patent rather than not, then by all means. But at least you have taken a decision on this. Now, as a segue to this, as a side issue to this, we have come across recently a situation where an invention is partially patentable, but partially not patentable because it wasn't, it didn't satisfy the inventive step. Or rather, there was more than enough intelligence and information that we got during the searches to tell us that it doesn't satisfy the inventive step. So what we did was we looked at the other options available and we said, okay, look, if you don't consider patent, would you then consider a registered design? It's novel, but it doesn't satisfy the inventive step, right? It has some aesthetic value. Would you consider that as an alternative to the a patent? The idea is this: you want to have some IP protection, some formal registration, formal IP registration, but you don't satisfy all the requirements for a traditional patent. So what can you do? You see, so with this kind of shall we say approach, so we took an open, we went in with an open mind. We said, okay, look, whatever it is, your commercial plans, you wanted it to be you wanted to go down this path. That's fine. You wanted to reveal everything through a patent. That's fine. But you find that during the searches, during the prep, it's probably you will not succeed. So then what are the options? Okay, so this is where the value of IP mapping also comes in. This is, okay, look, if you can't do option A, at least you go to your plan B or plan C, right? You still can fulfill some of your original intentions, right? And at the same time, you still can get alternatives that you might be able to commercialize according to your original plans.
And again, do you have, say, specific examples of, I guess, a case that you have done?
Wow, I can't really reveal some of these because some of these are in the process. Right, this IP mapping thing is something that we recently started, and we are actually helping some people actually overcome some of the, shall we say, qualifying criteria, the difficulties they face with qualifying criteria, in order to overcome those criteria and give them solutions. So, I mean, the example I gave just now, where a patent, you can't obtain a patent, but you look for a registered design instead. You see, so that's one example. If you want, I can cite other examples that we've come across. Things like, I heard that there are people who have obtained patents for creating pizza, the method of making pizza, right? They actually filed and obtained patents for the whole baking process. Okay, because apparently they discovered something novel and innovative in the science of pizza making. Okay, similarly, I also came across recently patents in the art of making beer and making coffee. So there are people who have actually obtained patents for such processes. So again, like I said, these things and all that, you just keep an open mind, and you'll be surprised what kind of IP protection you can actually discover and obtain over your everyday, your assets, your products, or whatever process you are actually building.
And so we have been, yeah, so I guess we have been talking a lot on the value of IP mapping and all that also. I mean, to set some context, could you also elaborate, say, how long, maybe a time period of this exercise? Because we know that, I mean, in startup world, time is of the essence, right? And especially during this period, if, say, license and licensing is required as an additional revenue stream for the startup, for example, then how long would this IP mapping exercise take on average? Is it industry dependent, or what does it entail, the timeline?
That is actually quite true. It's actually industry dependent. I would say a lot of it will depends on the urgency of the party itself, because you have to conduct tests to see how ready your product is. Okay, and of course, before you actually commercialize and put it into the public domain, you will want to have some kind of protection. So this is where the alternative comes in. Okay, because if you find that certain things and all that, the time to launch, but actually it doesn't make sense. If you are not ready, or rather, if your product is ready, then you should be ready to file the protection as well, because all of these things will have to be in place. Now, you ask for an indicative time. Okay, it could be weeks, it could be months. It really depends on how fast people want to move. right? How urgent they are, how dedicated they are in actually getting the product ready for launch, right? And then of course, simultaneous with ready for launch is how ready they are if they want to get the product protected with the relevant IP protection, right? So yeah, it could be weeks or it could be months, depending on how fast you move.
Yeah, so you mentioned that I guess as long as they have a product, a ready product, you can consider seeking IP protection. Say in the case of an early stage startup, for example, would you recommend that they think of the first IP protection if they're really in the early stages, considering that the algorithm might potentially change in a couple of years later?
See, here again, I hesitate to recommend any protection which will then go on to reveal all your trade secrets and innovation to the public. I hesitate to say this because I believe that you need to find a balance between what you want to reveal, right, against what you want to protect. Okay, now, of course, if you say that the technology is going to be superseded very quickly and all that, and therefore, you don't need to worry about so much about revealing so much or even protecting it. Okay, then yes, by all means, go ahead and get it protected. Do it quickly, as early as possible. Once your product is ready and you feel that you're ready to go to market, you've got all your branding strategies already, advertisements and all that already, then sure, please go and get it patented as quickly as you can. Okay, of course, I say all this, you've got to be ready with the satisfying the qualifying criteria. Okay, so novelty, inventive step, industrial applicability for a normal patent. And what usually happens is that, again, comes back to full knowledge. We always stress before you do anything, the prudent thing to do is to find out as much as you can about the state of the art, so that when you go and do your protection, it is with eyes open. You understand exactly what are the parameters beyond which you cannot act, and what protection you can conceivably claim. Okay, I mean, if I just give an example like what we are currently doing now, somebody has an invention, they have 4 parts they want to protect, 4 parts. We did all the searches, we did analysis, we told them, okay, 2 parts you can protect. The other 2 parts, it's 50-50 or even less. You might not make it, right? Do you still want to go ahead and claim for all 4 parts? Right? So they took the decision, they say, okay, fine, we want to go for all 4 parts first. Whether or not we succeed is another story. We are more confident with 2, we are not confident with the other 2, but we go ahead and go ahead with it first. Right? But one of those parts which were going to fail, we said, okay, look, why don't you consider an alternative form of protection, registered design? So that is still on the table. And that is something we said, okay, look, if conventional protection, patent protection, you cannot get, would you consider an alternative? So this is just one example where we took all the factors, we did the searches and all that, and we realized that one of these parts could qualify for registered design if they wanted to. And that gave them the option to consider, okay, look, if you fail in the patent claim, would you then be able to succeed in the registered design? That option we gave to them.
Thanks, Rizvi. And I guess to end off for today, my question would really be, given that this is I guess a very important exercise to recognize your assets for the company, what are some of the steps, if you could recap some of the key steps that founders need to take note of when they are doing this exercise?
Okay, I think one important area is co-creators. People who have contributed to the creation of the, or contributed ideas. to the creation of the product or the asset or the piece of work. Okay, it's very important to resolve issues of ownership, because if not, then the other co-creators might in the future come back and take a claim. And if you find that you have not resolved that fully, then it might become problematic for you. Okay, co-creators. And let me see. Co-creators is one. Keep an open mind. Second thing is keep an open mind. Don't be sort of like obsessed with, having one kind of protection only. Keep your mind open until you exhaust all your options. And of course, with options, in order to know all your options, you need to have as wide an area of knowledge, intelligence, intel, if you like, on the particular state of the art, so that you can make a very well-informed decision where you want to go. And of course, the other thing is you decide the pros and cons of actually revealing all the trade secrets and the innovation in your technology and your know-how as a trade-off against obtaining the monopoly or the IP protection that you seek.
Okay, thanks,
Okay.
Rizvi. Yep. Thanks, Rizvi, for the summary. And with that, we will move on to our Q&A segment. For anyone here to actually ask questions to Rizvi, well, I'll give you some time to think. We have one question. Maybe you can address that question first from Steve. Can you share the process of doing up a trade secret with a lawyer in Singapore? How much does it typically cost, and what type of protection does a trade secret filing provide?
There's no how do I put it? There's no filing of a trade secret as such. Trade secret is protected by documents. You don't file anything. So what you do is, okay, if I use an example of a recipe, okay, a recipe. Now, some people keep the recipes in their head. Some people have to write down, like and put it in a sort of like reduce it in writing. Okay, now, but whatever it is, keep that safe and secret. Don't reveal that to anyone. Okay. Now, if you have to share it with people for the purposes of, say, manufacturing or what have you, then you ask yourself, okay, look, how do you bind them to an obligation of confidentiality to keep secret your trade secret that you share with them? Okay, so that the law will recognize that through what we call confidentiality agreements or NDAs, where you agree to share with somebody your trade secret in return for which they agree not to use it for other purposes or share it with other people. Okay, so that process is either a confidentiality agreement or a non-disclosure agreement. That is the most basic way of protecting a trade secret now.
Okay, thanks, Rizvi, and thanks to Steve who asked that question. I hope that answers your question. To the rest of the audience here today, I ask that if you would like to ask Rizvi any questions, you can actually unmute yourself and ask the question now. We have a question from Su Yan. How do we enforce NDAs?
How do you enforce an NDA? Okay. If you're talking about going to court, basically there's a few things. If you feel that the NDA is going to be breached, not yet breached, but going to be breached, you can always go to court and get an, what do you call it, interim court order to stop the person from breaching it. That will be probably the most valuable remedy you can get, because at least you maintain your secrecy, if you like. If, of course, the NDA has already been breached, they've already disclosed it in contravention, and you want to get some remedy, then you just sue in court now. Sue for breach of the NDA, then you need to prove how much you have lost. Okay?
Thanks.
Okay.
Thanks, Rizvi. Okay, the next question is, can we protect a domain? For example, xxx@ace.org.sg. I guess this person, June, is asking if you can protect a domain to prevent misuse of that particular domain.
Domain name, okay. Okay, I'm assuming when you say protect from misuse, someone has registered this name with a domain name registrar and is using it for other purposes or whatever. Okay. I think you give an email address, but yes,
that's right. That's right. Because we actually experienced someone using the similar domain to actually give fake information on certain items. So you did try to check with the domain registrar. They actually found out it's actually someone actually registered with the same domain, but actually was actually subsequent to the initial pioneer register.
Okay. So when you say misuse, there is some civil or criminal wrongdoing that they have committed.
There is some fraud going around, but
fraud, I see.
Already reported, but it's actually still, we just want to see whether there is anything that we can do other than just a domain registration protection. That means you register with the domain will actually, the registrar will try to actually help you to scrutinize new similar domain will be registered. However, there is actually a case, a similar domain was registered. So we make a complaint, they actually revoke the registration on the article domain. But however, there was actually some articles or some communications is really out from that domain.
Okay, so there's two different issues here, okay? Because the actual domain itself, the domain name, as you rightly point out, there's an administrative procedure to actually compel the, shall we say, the current owner of the domain name to surrender the domain name. That's one thing. Now, the other thing which you're talking about is the actions, the behavior, the conduct of the people owning the domain name. Now that, of course, you have to take the necessary action, whether it is fraud, you complain to the police, or if it's civil, like misrepresentation, or like cheating. It sounds more like criminal case, you see. So usually for the police, a criminal case will definitely necessarily mean you need to look for a perpetrator. You need to look for a villain, someone who is responsible. They can be caught, can be prosecuted, brought to justice.
But because actually we want to find out whether there is, like, for example, similar like an IP register, can we actually do a domain to actually register under an IP as an IP?
You mean you register a domain name as an IP?
Can I? I just want to actually find out.
Okay, I think you can. This was done many years ago by, I think, if I remember correctly, there was one case in the UK some time ago. Somebody tried to register, but if I'm not wrong, if I remember correctly, what they said was that they do not recognize the what do you call it, the .org.sg. They will just, they will ignore those elements, right? .com.sg, .org.sg, .net, they will ignore those elements. They will look at the rest of the domain name to see whether it is actually registrable. That's number one. Then number two, once it's registered, you must use that as a trademark.
We did so. We already registered trademark.
Okay, so if you use that, then of course, if anyone wants to misuse that, but you can only take action if they're using it as a trademark, not if they are using it for like a domain name,
Yeah, that's why we know that it's actually under trademark protection, but it's actually more on domain being misused. They actually pretend they are actually a so, but however, when it comes to the content of the emails or the correspondence, is actually totally not something like that.
Then that could be passing off also, or that could be other things that could be criminal element also.
Yeah.
Okay, jumping in here. Sorry, jumping in here. We will have Rizwi's contact at the end of the session. Happy for any of the attendants to take your conversations further.
Okay, can do.
Yeah. So since we were talking about trademark, in the interest of time, we will also take our last question. We were talking about trademark earlier when June asked about the domain registration. So what is the criteria for a trademark? Which is also asked by Jeremy. As a case study, how come Hai Di Lao wasn't able to protect their trademark against a rival company?
Hai Di Lao wasn't able to protect their trademark. So what is the context of this when you say they couldn't protect their trademark?
Oh, hi, Rizwi. Thank you for a very informative session. Okay, so I was reading in the newspaper that there's in case you didn't know, there's a company called Hai Di Lao. It's a Chinese hot pot.
Chinese hot pot restaurant, right? Okay.
Yeah, and apparently in China, there's another hot pot company that created another, basically named themselves He Di Lao. So basically, and so Hai Di Lao tried to file a lawsuit against He Di Lao, saying that they are infringing on our trademark. So my question, what I'm wondering is, and then Hai Di Lao wasn't able to win that court case, and immediately Hai Di Lao went to file, I think, for hundreds of names that are similar to the name Hai Di Lao itself. So I'm just curious, what is the criteria for a trademark? Because patents, we know about novelty, how practical it is. What's the criteria for a trademark? And maybe how come Hai Di Lao couldn't protect itself against a rival company that has a very similar name?
Okay. I think the question here is, I think, who came first? Okay. Now, have you heard of this story about Hungry Jacks in Australia?
Yes, I heard about it. Yeah, they were a copy of Burger King's, I think.
No. Burger King, when they wanted to, Burger King in Australia, the Burger King as we know, right? In Australia, they're known as Hungry Jacks. That's because in Australia, there was already somebody who was using the brand name Burger King before they came in. Right? It's a long story. There's some history involved, but the gist of it is that whoever came first, used the name first, will, in that particular territory, will have the sort of like the priority over other people. So when you talk about this Hai Di Lao and He Di Lao, I'm guessing that one possible reason, I mean, I don't know the full story, one possible reason is because He Di Lao was there first. Is that right?
For this part, I'm not too sure. That's why I'm asking. And also, what are the criteria for a trademark? What are the criteria that's needed for a trademark?
Well, it must be a sign capable of distinguishing your product or your business. You see? So, I mean, following on from this, anything which is very generic or very nondescript, you probably will face some objection or queries from the registry, unless you use a very nondescript brand which is very well known already. So the most obvious example is Apple. Apple by itself is actually quite a simple, it's a simple word, it's a simple fruit. But because Apple is well known for already some time for computer related products, right? It is not difficult for them to register in relation to computer products. Now, if you register the word Apple for apples itself, that might be a problem. Okay. Now, I don't know whether you remember many years ago, there was this very well-known English pop group called the Beatles. So what happened was, I think there was this group, there was this a record company called Apple Records. And for the longest time, or there was a very famous court case, I think in the UK, UK or US, I can't remember, but there's a very famous where Apple Records and Apple went head to head with each other because they both insisted they had this sort of like rights or monopoly rights to the word Apple. Although one was actually a record company, the other one was more computer related, and now iPhone now, you see. Now, let me ask you, have you now you hear about Apple Apple company for the iPhone, but do you still hear about Apple Records nowadays? They're probably still around, but not as famous now. Okay, so if you take all of these things into consideration, criteria for trademark, it must be able to distinguish your business or your product. Okay, that's one thing. If whether by long user or as if it's inherently unique. Okay. Now, but when it comes to things like fighting with competitors and all that, the smart thing to do is to whoever came first, right? Whoever came first and established the reputation first is probably the one that will prevail, probably. Okay, unless there's some dishonest conduct involved. Okay, but nowadays with the sort of like the world is getting smaller, so you can imagine if I come up with a brand name in one country, right? If I'm really worried about my international reputation, it will make sense to quickly go and protect it in other countries. Otherwise, when other people find out, they quickly copy. Before you know it, your products will be start selling in Ukraine, Belarus, Kurdistan or wherever, and you cannot do anything because they've already used your brand name there first. You know, things like that. I hope this sort of like helps you. One last question, if there's time. What are the ways to check if other companies are infringing on startups' patents? Oh, simple question, expensive answer. If you want to check, come on, I'll take this last question now. Okay.
Sure. Okay.
Last question. If you want to check whether someone is infringing on your patents, okay. First of all, you will need to know how, or you need to have some grounds to suspect someone is infringing on your patent. Okay, either in the form of a final product that is being produced, or the actual product itself, that you see, okay, you know, it looks very similar to what you have, and its functionality is very similar to what you have. Okay, so you need proof. You need some expert evaluating the actual product or the process to see whether it replicates the essential integers of your patent, the key elements of your patent. Okay, then, but what I will caution you is this: if you are going after an infringer, you find the infringer, you take legal action against the infringer. The first thing they will do is they will actually seek to invalidate your patent. You see, they will recognize the vulnerability of the patent and they will say, okay, first thing we do is we will stop the patent owner. Okay, so then you'll find yourself embroiled in very expensive and heavy-going patent litigation. Very painful, very slow, very laborious, and very expensive. Okay, so you need to make a decision whether it is worth, expending all these resources and time and energy on such things or not. Okay. I hope that helps you in your answer.
Okay. Thanks, Rizvi. And with that, we have come to the end of the event. Thanks everyone once again for joining us today, and thanks Rizvi for the insightful discussion as well. I'll leave our contact channels here, both for Ace as well as Rizvi's contact. You may also check back on our events page or social channels next year for updates on the next topic for our Ace Teh Tarik series. And with that, goodbye and see you for the next event.
Thank you. Bye-bye.
Thank you.